of the day, and to do so, our second shift is here. As Senator from the 20th will recognize our Doctor of the Day.
Thank you, Mr. President. It's my honor to have Dr. Zoeb Budwala here with us today. Appreciate him taking his time to give us his services this afternoon. Dr. Budwala was born and raised in Decatur and attended undergrad at Emory University. He received his medical degree from Mercer University School of Medicine and completed his residency in internal medicine there. Dr. Budwala proudly practices internal medicine in Warner Robins, Georgia, where he lives with his family and his precious 17-month-old baby girl. Please give Dr. Budwala a warm Senate welcome. Thank you.
I just want to say thank you for I'm honored to be here. You guys are doing very important work, and I'll be, if you need me. Hopefully you won't need me, but if you do need me, you know where to find me. All right.
If someone could help me locate the senator from the 18th. Chair recognizes Senator from the 18th.
Thank you, Mr. President. I move that the Senate adhere to its amendment to House Bill 906 and that a conference committee be appointed.
Secretary will read the caption.
House Bill 906 by Representative Dempsey the 13th and others, the bill will be titled Enactment Article 4 of Chapter 18 of Title 50 of the OCGA relating to inspection of public records so as to exclude public disclosure of personal information of certain foster parents and for other purposes. That concludes the order.
Is there objection? Without objection, we're going to put it in conference committee, and the conferees will be Senator from the 19th, Senator from the 18th, Senator from the 17th. 17, 18, and 19, not because they're capable, but just that their numbers were all in order. This felt like a good thing to do, 17, 18, 19. Chair now recognizes Senator from the 17th. Huh? No, I'm sorry. Where's it? Okay. All right. Chair recognizes Senator from the 1st. You want to make a motion to agree to the conference committee?
Mr. President, I'd like to make a motion to agree to the conference committee report on House Bill 217.
Okay. You are recognized to speak to Secretary, read the caption.
Committees of Conference report on HB 217. The Committees of Conference on HB 217 recommends that both the Senate and the House of Representatives recede from their position that the attached Committees of Conference substitute to HB 217 be adopted, submitted by, for the Senate, Senator Watson the first and others. Committees of Conference substitute to HB 217, a bill will be titled Act to amend Article 2, Chapter 7, Title 40 of the OCGA relating to imposition rate computation exemptions from state income taxes so as to increase the amount of the aggregate cap on contributions to certain scholarship organizations in order to receive income tax credits for other purposes. That concludes the order.
Chair recognizes Senator in the 1st.
Thank you, Mr. President. I'm here to give the conference report on House Bill 217. The changes that we made, or made better, I should say, was that we did put a 10-year a limit on the tax credit, and then we tightened up the language relating to the reporting requirements relating to the, rather than quartiles, we use the federal poverty level, which is makes it a little bit better to understand. And then there was the addition of language in the section 4 relating to let's see, through Billy Graham's language that a Georgia 501c3 organization being charged a use tax for a non-commercial written material or mailings. And that's basically it. If you'll see that that all 6 of us agreed on the conference committee through lots of negotiation, and that's about it. I'll be happy to answer any questions. If not, I'll yield the well.
You do have a question. Chair recognizes Senator in the 41st.
Senator Yield.
Yes, sir.
Could you go over again about language that may allow us to better research, study, and understand the breakdown of people using SOSs now? Because that has been a big concern. So is there greater openness and transparency?
Right. So the reporting now will be a 5-year review and a sunset at 10 years. There's annual reporting every year, but the standard way of reporting is also is clarified. If you'll see, I think it's lines 123 through 132. That's that section there.
Senator, further yield for a few questions.
Yes.
Would that reporting allow us to determine, you know, what areas of state they are, what race, and what economic conditions they derive from?
Right. Well, it's going to look at the public benefit, the economic activity, the state expenditures, but not limited to the cost of the tax credit and the net change in state revenue. And you'll see specifically related to your questions, lines 151 through 156, the federal poverty levels and so forth there.
So someone wanting to research what amount of percentage of people every year are in a certain economic status, that will be available.
That's accurate.
But we would not necessarily be able to break down by race or gender.
You know, I don't know the answer on the gender or the race. I really don't know that answer.
Is there, Senator Further Yield, is there any qualifications on the SSO, I'm sorry, that possibly, right now there are one or more that have only like one contributor to it. And there's been some concerns about there. Is there any regulation requiring multiple people to be contributors to SSO, or any new qualifications on SSOs?
No, that was part of the discussion that was not put into this legislation, but again, we'll have the information annually. We'll review it in 5 years, and that will be part of the discussion there.
Senator Further Yield.
Yes.
In your discussions, what was the concerns expressed or your considerations that this money, of course, will no longer be available in the general budget for the general education population, going to private school grants or vouchers? What were the concerns expressed on that, that we're losing this money out of the general fund for public schools?
Thank you for your questions. Certainly in my area, the private schools are Bethesda, which used to be an orphanage, and it is for boys. It is for children that are in poverty-stricken areas. In my area, it's used for children that are underprivileged, and that it won't cost the state any money. It's shifting the money over to them. So I think it's a good thing. It's not a voucher, but I think it is a good thing from that standpoint. And that's what we'll define going forward in the future. Thank you very much. If there are no further questions, I'll yield the well and ask for your favorable consideration.
You have one more question. Chair recognizes Senator 37.
Does Senator yield?
I do.
Did y'all look to see what portion of these funds were taken up by corporations on the first day?
I don't have that number off the top of my head, but you're correct. That is an issue, because the $58 million that's taken up really within the first day or so, and that's part of the reason how popular it is, and what the state of Georgia feels as if what their citizens want their money directed towards. And I'll tell you, I agree with you. I think that it should be expanded more. It is expanded to $100 million. Should we do like some of the other states and expand it much more? That's to be seen. But it is taken up by a significant percentage of corporations, and we'll get the breakdown of what those corporations go in what particular areas.
Does Senator Further yield?
Yes, sir.
Are you aware that 3 or 4 years ago, one corporation got $5 million in a single corporation on the first day?
So, I think that's necessarily a good thing. I think it's good that they would support the children to get an education and under this particular situation. That's my stance on that.
Does Senator Further yield?
Yes.
Did y'all discuss the fact that this is 100% state tax credit that's transferable or saleable, in addition to being able to get a federal tax deduction as a contribution? So that it's an actual positive gain from a cash flow to all people who give it. It's more than 100% value.
I think that's part of the equation.
So we're paying money to subsidize people to do this?
I think that is a very small percentage, but I don't think that's the intent. And certainly we'll look back at 5 years or so. I agree that many people, from a public school standpoint, are not necessarily for this, and I'm not trying to win you over. So, but I will tell you from a standpoint of helping children in our great state of Georgia, I think this is the right thing to do, and this is the right time to do it, and to expand it is the right thing to do.
Does the senator further yield?
Yes.
Is it not true that the limitation on a couple filing jointly is limited to a $2,500 credit?
You know, Senator from 37, I will tell you, the tax policy relating to this, I would presume you know what you're speaking of.
Does the senator further yield?
Yes.
Does it seem strange that we'd give a $5 million tax deduction to a corporation when we only give a $2,500 deduction to a couple filing jointly? You know,
I'm certainly happy that that a donation of $5 million, that their taxes are directed towards the children for their education. I'm certainly very happy with that.
The senator further yield?
I thought you said last question 2 questions ago, but I'll yield for one more question, Senator.
I just was questioning the logic behind giving them a 100% tax credit in addition to a possible 39% deduction on their federal tax return.
Your concern is noted. I appreciate that.
Chair recognizes Senator from the 40th.
Senator Yield?
I will.
Senator, isn't it true that one of the concerns about this program over the years has been the lack of transparency about who's getting the particular scholarships? Is that not true?
That is true.
Is it further not true, and I appreciate this very much, that in this conference committee report, for the first time, between lines 151 and 156, we are showing the number of children by category based upon the percent of the poverty level, and then when we get this data in, it will show and prove that majority of these particular grants, if you will be going to children of economic means that are disadvantaged. Is that not true?
I think that is absolutely true. The Student Scholarship Organization, or SSOs, this is going to be annually done, and then we'll have a 5-year review of that.
Thank you so much for including this in the conference committee.
Thank you. Mr. President, I'm going to yield the well and ask for your favorable consideration. Thank you.
Thank you, Senator. Chair recognizes Senator from 36.
Thank you, Mr. President. Senators, I rise in opposition to this bill. We just heard from the senator carrying the bill that we don't know this, we don't know that, and we don't know the other, and we're going to ask for them to give that information. When this legislation was originally crafted, it had explicitly masked the information. It even disallowed the Department of Revenue commissioner to make inquiries. That's how baldly they were protecting this information. And when you see that effort to cover up transactions dealing with money, I say alert, alert. Look a little further, dig a little deeper. Why are they trying to mask this information? I don't think there's any place else in the Georgia Code that had that kind of language barring the Commissioner of Revenue from inquiring and getting details and facts from these organizations. And it's taxpayer dollars that are involved. That is to say, our general revenues go down when you shell out this money. Now, why this effort continues to be masked and treated differently from so many other things really causes concerns. I will say to you that the Georgia Senate Study Committee on Special Tax Exemptions outlined a series of recommendations that include descriptions of what should accompany these tax incentives, that they should be limited to 5 years and looked at, and that included the tax credit scholarship program that is in this very bill. And this kind of rigorous approach making informed decisions about the best use of state's resources is a real step forward. They're members of our finance committee here in the Senate, the chair and the vice chair in particular, who have led the way in calling for more transparency. But this bill is not a 5-year sunset for review. It's a 10-year. What justifies making this a 10-year? And we have questions saying, isn't it true that these are students in poverty that are helped? Well, you know, we really don't know that, do we? But yet we're going to almost double, go from 58 million to 100 million with a swoop of a pen in one bill. That's justified when we don't even have the data? Why aren't we asking for the data and then come back in 5 years and determine, is this meritorious, and do we move it up to 100 million? We've gone about it improperly, and people have fallen silent in the face of it and not challenged it and not questioned it. One has to ask why, and I appreciate the numbers that the chairman of our Senate Education Committee pointed out about the enormous tax advantage that you get from this. That's not even clear when you read the bill, but both on the federal front as well as on the state front. And we've had a lack of the barest standards for transparency last year, and the questionable claim of an out-of-state program that is excelling. Let's look at what our track record here is in Georgia. Do you know how long we've had this thing on the books? We have 10 years on the books that we've been doling out this money. And are we willing to just remain in ignorance? Apparently, there's a desire for more transparency. That's in the bill. But why, I ask you, would we almost double the money, the tax expenditure out of the state budget on this, from 58 million to 100 million? I've not found anybody that can give me an answer to that because the data's been shielded. We haven't had it. And if you want to study data and make informed decisions, which was the whole thrust of the Senate Study Committee on special tax exemptions, let's gather the data. Are we afraid of the data? Do we want to rush and double this thing to $100 million without the data and then wait 10 years to do a look back? That would be 20 years of running a program before we have data to justify whether we continue it or adjust it or do away with it. I just say to you, on the face of it, there's no rigorous approach to this program. And the fact that, as the chairman of education just pointed out, that some specific organizations and corporations are showing great gains in their bottom line from engaging in this. I'm highly skeptical. I would urge you to just apply common sense in looking at this bill and at this program, which has been on the books for 10 years and was written with it explicitly barring the Commissioner of Revenue from inquiring into the details. We're better than this. We know better than this. We don't need to be hoodwinked into just giving away tax dollars. So if you're comfortable voting for it under those conditions, that of course is the right of each and every individual in this room when we cast our vote. But I would say to you, alert, alert. It should be this of course is a conference report, but it should have been a 5-year sunset on it for it to be examined, not 10 years. What is this special privilege for? And we should decide on whether to expand the program or contract it based on the data that we gather in this 5 years. Am I being unreasonable? That just seems so perfectly reasonable to me and so obvious to be the pathway that we should be pursuing. Mr. President, if there are the hour is late. If there are no questions, I'm happy to yield the well. I'm happy to take questions. No questions. I'll yield the well. Thank you.
The senators move that the Senate adopt the conference committee report of House Bill 217. All those in favor vote aye. Those opposed, no. Secretary, unlock the machine. On the passage of the bill, the yeas are 34 and the nays are 20. This bill, or the Constitution, or excuse me, the conference committee report has been adopted. Chair recognizes Senator from the 50th. 50th. Senator from the 50th. 50th is recognized. 50th.
President, I move that the Senate insist on its substitute to HB 992.
Read the caption.
HB 992 by President Law of the 122nd, a bill be titled enactment Chapter 11, Title 31 of the OCGA relating to emergency medical services so as to eliminate certain requirements relating to the use of automated external defibrillators and for other purposes.
Senator has moved that Senate insist on its substitute to 992. Is there objection? Without objection, the Senate has insisted. Chair now recognizes Senator from the 18th.
Mr. President, I move that the Senate agree to the House substitute to SR 146.
Read the caption. Senator, I think we wanted to get 127 first, if that's okay. Had it queued up, so you'd be recognized to move on that.
Thank you, Mr. President. Then I move that the Senate agree to the House substitute to Senate Bill 127.
Thank you, Senator. Secretary, read the caption.
Senate Bill 127 by Senator Kennedy, 18th, and others, a bill will be titled enactment in Code Section 17, 1715 of the OCJ relating to the failure to provide notice not rendering responsible person liable or comprising a basis for error, the chapter not conferring standing, and for other purposes. The House offers the following substitute to SB 127, a bill will be titled enactment in Code Section 17, 1715 of the OCJ relating to the failure to provide notice not rendering responsible person liable or comprising a basis for error, and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator 18th to speak to the bill.
Good afternoon, colleagues. Soon to be good evening. I'm going to speak very briefly. This is Senate Bill 127. Following that will be Senate Resolution 146. It's with a little bit of pride and a lot of appreciation that I bring this to you. This is what we fought for last year, which is Marsy's Law. I want to express my appreciation to this chamber for your support of Marsy's Law. You have and you will be supporting that crime, that victims of crime in this state will have rights that will be found in our highest document, that is in our Constitution. I want to thank our president of this body for his support of this. I want to thank the House of Representatives and the work that they did to work on the bill that we sent them. And what comes back to you is a great bill, a great resolution that will go to the voters in November. And I feel confident that our folks back home are going to vote to put that in our Constitution. And I urge you to vote for this. And I thank you for the support that have gotten us to this point. Thank you very much. If there are no questions, I'll be pleased to yield the well. I do? Okay.
Chair recognizes Senator 23rd for a question.
Thank you, Mr. President. Will the senator yield?
Yes, sir.
What were the changes that were made from the time it left the Senate while it was in the House?
Thank you, Mr. Chairman. Senator, the 23rd, it was basically some procedural issues that were perfected with regard to how our bill dealt with and to some extent did not deal with what happens with a victim who wants to challenge the fact that their rights have been violated. And it provides the procedure for a motion to be made within the criminal case. It does clarify that the victim does not have standing to affect any conviction, does not have standing to affect any appeal, but it gives them a right to bring the issue to the attention of the court. It also clarifies the issue that you'll remember, Senator, with regard to the right for damages. There's no right for damages, but the rights are all sound in equity, and those rights that are in the resolution are well-founded, and we're very pleased to bring them to you. And I want to also, if I could, Mr. President, we've got some folks in the gallery that have worked very hard for the last 2 years.
Senator, you're not,
folks,
no, you can't. You're not allowed to do that, yeah.
I'm sorry.
Yeah.
I'm sorry, Mr. President. Thank you.
Chair recognizes Senator the 45th for a question.
Thank you. Will the gentleman yield?
Yes, I will. Be pleased to.
I just want to say thank you for working so hard for the past 2 years on this bill, and I know we've come a long way. So I was just wondering, in this substitute, does the prosecuting attorney's council still agree with whatever this substitute is?
Thank you for that question, Senator from the 45th. They do. The district attorneys across the state that I've heard from and from a representative capacity, PAC, agrees with and fully supports what I'm bringing to you.
Chair recognizes Senator the 19th for a question.
Thank you, Mr. President. Well, Senator Yield.
I certainly will, for my good friend.
Thank you, Senator. And you've done a lot of work on this, and I appreciate it. Is it not true, though, that a lot of people are here who helped you get to this point?
They did, Senator. I appreciate that question. A lot of folks worked very hard for this.
And a lot of them may even be around to watch us vote on this.
Might be very close. They might be very close. Thank you, Senator.
No further questions, Senator.
Thank you, Mr. President. I yield
Senator's
the will.
moving that the Senate agree to the House substitute to Senate Bill 127. If you're in favor, vote aye. Those opposed, no. Secretary unlock the machine. On the motion, the yeas are 54, the nays are 0. And this bill, the Senate has agreed to the House substitute. The chair recognizes Senator from the 18th again.
Thank you, Mr. President. I move that the Senate agree to the House substitute to Senate Resolution 146.
Read the caption.
Senate Resolution 146 by Senator Kennedy, 18th, and others. A resolution proposing an amendment to the Constitution so as to provide for certain rights for victims who have suffered or been harmed due to an act committed or attempted to be committed in violation of the criminal or juvenile delinquency laws of the state and for other purposes. Mr. President, the House offers the following substitute SR 146, a resolution proposing an amendment to the Constitution so as to acknowledge certain rights of victims against whom a crime has allegedly been perpetrated and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 18th. Final passage.
Thank you, Mr. President, and thank you, members, for that very great resounding support for Marcy's Law. You just voted to pass the enabling legislation. What's on before you now is the Senate resolution that would for the constitutional amendment. Thank you for your support. Let's make sure that the victims of crime in Georgia know that this body supports them and gives them the right to have their voice be heard and be recognized in the Constitution. I urge your support and thank you very much for your support.
Senator has moved. The Senate agree to the House substitute. All those in favor vote aye. Those opposed no. Secretary unlock the machine. On the motion, the yeas are 55, the nays are 0, and the Senate has agreed to the House substitute. Chair recognizes Senator 28th.
I move that the Senate agree to the House substitute to Senate Bill 286.
Read the caption.
Senate Bill 286 by Senator Brass, the 28th, and others. A bill entitled Enactment and Act creating the State Court of Troup County and for other purposes. Mr. President, the House offers the following substitute to SB 286, a bill be titled an act to amend and act creating the State Court of Troup County and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from 28.
Thank you, Mr. President. Ladies and gentlemen of the Senate, it's a simple bill. It's a local bill. Allows the state court in Troup County to put on a technology fee. It was $15 when it left the Senate last year. The House amended it down to 10. We found out that was going to be one of the higher ones in the state, so we decided to reduce that down to 10, and now it's back, and I would ask for your favorable consideration. That I'll yield the well.
The senators move that the Senate agree to the House substitute. All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. On the motion, the yeas are 49, the nays are 1, and the Senate has agreed to the House substitute to SB 286. Chair now recognizes Senator from the 11th. 11th. Senator from the 11th, from Bainbridge.
Thank you, Mr. President. I move that the Senate agree to the House substitute to Senate Bill 357.
Read the caption.
SB 357 by Senator Burke of the 11th and others, a bill will be titled an act amendment Title 31 of the OCGA relating to health so as to create the Health Coordination and Innovation Council of the State of Georgia and for other purposes. Mr. President, the House offers the following substitute as SB 357. The bill will be titled an act to amend Title 31 of the OCGA relating to health so as to create the Health Coordination and Innovation Council of the State of Georgia to provide for legislative findings and declarations, to create the council and assign for administrative purposes and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 11th speak to his motion.
Senate Bill 357 is our Health Innovation Council. That was the hard work of our task force that we had last year on health care. The changes in the House include a couple of appointments by the Lieutenant Governor and the Speaker, as well as specific appointments for a physician and a dentist. And then the only other change was some reporting requirements at the end of the year. I appreciate your support in moving forward on Senate Bill 357. I yield the well.
Senators move that the Senate agree to the House substitute to SB 357. All those in favor vote aye. Those opposed, no. Secretary, unlock the machine. On the motion to agree to the House substitute to SB 357, the yeas are 53, the nays are 1, and the Senate has agreed to the House substitute. Chair recognizes Senator from the 11th again.
Thank you, Mr. President. I move that the Senate agree to the House amendment to the Senate substitute to HB 769.
Read the caption.
HB 769 by Reverend Jaspers of the 11th and others, the bill be titled enactment chapter 4 to title 26 and title 31 of the OCGA relating to pharmacists and pharmacies and health respectively, so as to implement recommendations from the House Rural Development Council relating to healthcare issues and for other purposes. Mr. President, Senate offers the following substitute to HB 769, bill be titled enactment chapter 4 title 26 and title 31 of the OCGA relating to pharmacists and pharmacies and health respectively, so as to implement recommendations from the House Rural Development Council and for other purposes. Mr. President, the House offers the following amendment. Amend the Senate Committee on Health and Human Services, substitute HB 769 by striking 5 on lines 94 and 204, inserting in lieu thereof 7 by striking may on line 149 and 259, inserting in lieu thereof shall by striking or at the ends of lines 152 and 262, inserting in lieu thereof. And, Mr. President, that concludes the order.
Senators move to agree to the House amendment to the Senate substitute to HB 769. If you spoke to the bill? No? You recognize speak to the bill.
House Bill 769 is the results of the Rural Development Council from the other side of the hall. The changes in the bill that we passed are very minimal, and it involves the penalties for hospital authorities not getting the appropriate training that was recommended in the original bill. So they felt like they needed to strengthen those penalties to make sure hospital authorities were trained appropriately or educated appropriately to serve in those roles. There were no other changes of substance. I'd appreciate your support of House Bill 769.
Senators move that the Senate agree to the House amendment to the Senate substitute to House Bill 769. All those in favor vote aye. Those opposed no. Secretary, unlock the machine. Senator from the 45th will stand by. You will be next up. On the motion, the yeas are 49, the nays are 2, and the Senate has agreed to the House amendment to the Senate substitute. Chair recognizes Senator from the 45th.
Thank you, Mr. President. I move that the Senate agree to the House substitute to Senate Bill 118.
Read the caption.
Senate Bill 118 by Senators Unterman of the 45th and others. The bill will be titled enactment code section 332459.10 of the OCGA relating to coverage for autism, so as to change the age limit for coverage for autism spectrum disorders for an individual covered under a policy or contract for other purposes. The House offers the following substitute to SB 118. A bill will be titled enactment code section 332459.10 of the OCGA relating to coverage for autism, so as to change the age limit for coverage for autism spectrum disorders and for other purposes. That concludes the order.
Chair recognizes Senator from the 45th. Speak to the motion.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I bring before you Senate Bill 118, and this is the issue of autism that we have worked on for many years now, and we're very pleased to be able to bring autism insurance coverage to the same example for private insurance as we do for the state health benefit plan and for Medicaid. I urge your favorable consideration of Senate Bill 118. I'll be glad to answer any questions. If there's no questions, I yield the well.
Thank you, Senator. Senators, move the Senate agree to the House substitute to SB 118. All those in favor vote aye. Those opposed, no. Secretary, unlock the machine. Senate Bill 118. Unlock the machine. What? Chair recognizes Senator 45th.
Mr. President, is it not true that some people in here are having fantasies about different bills? Is that not true?
On the motion to agree to the House substitute to Senate Bill 118, the yeas are 50 and the nays are 4. Chair recognizes Senator from the first. From the first. 395. Do you not have the card?
Mr. President, I'd like to ask the Senate to agree to Senate Bill 395.
Senators moving for the Senate to agree to the House substitute Senate Bill 395. Read the caption.
Senate Bill 395 by Senator Watson, the first and others, a bill we titled Enactment Article 10 of Chapter 7, Title 50 of the OCA relating to the Defense Community Economic Development Fund so as to create the Georgia Joint Defense Commission and for other purposes. Mr. President, the House offers the following substitute to SB 395, the bill we titled Enactment Chapter 4, Title 20 of the OCA relating to vocational, technical, and adult education so as to create the Georgia Joint Defense Commission and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the first to speak to the motion.
On Senate Bill 395, this was the creation of the Georgia Defense Initiative Commission. There were some minor changes in the House that we were fully in agreement with. The change relating to the placement of the workforce development into the economic development, and that was it. Ask for your favorable consideration.
Senators move to agree to the House substitute SB 395. All those in favor vote aye. Those opposed, no. Secretary, unlock the machine. On the motion to agree to the House substitute to Senate Bill 395, the yeas are 54 and the nays are 0, and the Senate has agreed. Chair recognizes Chair recognizes Senator from the 17th.
Mr. President, I move that the Senate agree to the House substitute to Senate Bill 407 as amended by the Senate.
Read the caption.
Senate Bill 407 by Senator Strickland on the 17th and others, a bill will be titled an act to provide for comprehensive reform for offenders to amend Title 15 and Chapter 6A of Title 35 of the OCA relating to courts and the Criminal Justice Coordinating Council and for other purposes. Mr. President, the House offers the following substitute to SB 407, a bill will be titled an act to provide for comprehensive reform for offenders entering, proceeding through, and leaving the criminal justice system so as to promote an offender's successful reentry into society, benefit the public, and enact reforms recommended by the Georgia Council on Criminal Justice Reform and for other purposes. Amendment 1 by Senator Dugna, 30th, offers the following amendment. Amend the House substitute to SB 407 by replacing July 1st, 2018 with January 1st, 2019 on lines 63 and 152 by replacing lines 77 and 166 with the following paid to supplemental fee of $5 and for other purposes. Amendment 1A by Senator Cowser to the 46th offers the following amendment. Amendment 1 to the House substitute to SB 407 by adding the following by striking lines 145 through 206. Mr. President, that concludes the order.
Chair recognizes Senator from the 17th.
Thank you, Mr. President, members of the Senate. Senate Bill 407 was the final piece of the Governor's Court Reform Council, Criminal Justice Reform Council, actually, the final piece they had that dealt with bail reform this year. They passed out his body unanimously earlier this year. And on the House side, there was a couple of amendments they added to it. One of them deals with e-filing, and I think the senator from the 30th and the senator from the 46th will address that with their amendments as well. The other thing they added to this was the bill we passed that dealt with the jurisdiction for security at technical colleges in our state that would give them the same jurisdiction within 50 yards of their schools that our colleges currently have as well. And with that, Mr. President, I'll be happy to answer any questions.
There are no questions, Senator.
Ask for favorable consideration.
Chair recognizes Senator from the 30th to speak to Amendment 1.
Thank you, Mr. President. If you look on Amendment 1, all it does is basically some clarification on that. We had an original implementation date of July 1st, 2018, and we decided that may be a little fast, so we took that to January 1st, 2019 before compliance. You see a supplemental fee of $5 for each filing made in a civil action after they've made 10 electronic filings. The 30-cent piece on line 8 there is just a clarification. When you look at it, they didn't want to be any confusion as it's per transaction. And then down at the bottom, starting on line 16, if you've already started a paper process before the mandatory date goes in, you can continue through the duration of that using the paper process. You don't have to shift mid-stride into the electronic filing. And then the next one is, I don't want to try to confuse you, but if December 31st is the last day that it's not mandatory, all that section is saying is between July 1st and December 31st, you can go ahead and voluntarily start shifting to total e-filing. You just have to be mandatory by January 1st. Subject to your questions.
Chair recognizes Senator from the 28th for a question.
Thank you, Mr. President. Does the senator yield?
I yield.
Senator, we've been hearing reports that, there's some local mandates that really aren't real consistent. Do you think this bill is going to add a little consistency or really price protection for our Georgia attorneys?
Exactly. Thank you for asking that question. What it does, instead of just morphing over time into a hodgepodge of different cost points and inefficiencies, this lays out a standard. It creates efficiency and saves costs overall.
Fair enough. Thank you.
Thank you.
Chair recognizes Senator from 46 for a question.
Thank you, Mr. President. Will Senator yield for a
Aye.
couple of questions?
I'll yield for one first, and we'll see where we go.
Excuse me?
I'll yield for one first, and we'll see where we go, because you and I have had multiple conversations about this, so we'll see where the line goes.
Well, am I accurate that the subject matter that you're dealing with in your amendment deals with civil filings rather than the criminal justice system, and it was added on in the House despite the fact that their bill last year is hung up in a conference committee where we can't reach agreement?
The senator from Athens is right. It is hung up in a conference committee because there were two people that could not reach an agreement. This bill passed 170 to nothing in the House. It has widespread support of other attorneys here within the chamber. We did hit a wall with two non-votes, not no votes, but non-votes in the Senate. Of the senators.
Two of the three conferees didn't
Two
agree.
of the three conferees.
And does this bill guarantee your constituent from your districts, 139 counties that they already have contracts in with the clerks of court, that folks will have to be required to use their services to mandatory file?
That is not true. Matter of fact, what the bill says is when you get into it, if you have a contract, you go ahead and maintain that contract. After that contract is expired, then you can bid out other contracts, or you can maintain the person that or the organization or group that you already have.
Thanks, Senator.
Mr. President, I yield the well. Ask for your favorable consideration on Amendment 1.
Chair recognizes Senator from the 46th speak to Amendment 1A.
Thank you, Mr. President. Ladies and gentlemen, this bill we passed out, Senate Bill 407, is part of the governor's criminal justice reform package. I served on the commission representing the Senate, and the underlying bill that we passed reflected the recommendations of that Criminal Justice Reform Commission. We sent it over to the House, and it has come back with a add-on, this section 1-3 that begins on page 5 and goes through page 6, that has nothing to do with criminal justice whatsoever. It deals with the civil justice system, with lawsuits amongst parties, not anything to do with crime. It is not part of the governor's package. It mandates that every clerk of court provide electronic filing and requires the parties in every case to use that. As it was written, I believe it starts it on January 1st, 2019 in one place. And if I wasn't mistaken, in another, it talked about being effective this July. I don't think it's possible for courts to develop, design, implement an electronic filing system if they don't have one. There are a number of counties in the states that don't have it. Now, we talk about local control, local rule. You're putting a mandate on these counties. They are required to accept it. It also sets a fee, $30 per party to a case. Now, that means the plaintiff has to pay a $30 fee, and each defendant, maybe more than one plaintiff. This national average is somewhere around $20 per case, and this, you can tell, with two parties will be at least $60 per case required on top of the $214 or $15 filing fee that parties are already paying. We passed a bill last session, House Bill 15, that dealt with electronic filing. The Senate position was, and our bill held, that it would be voluntary. If you chose to utilize the convenience of the electronic service, then you would pay the fee. You wouldn't be mandated to do it. Now, we're going to get there eventually as these counties build out their electronic filing capabilities, and folks will eventually want to do that. You may or may not remember last year I was complaining. I was involved in about 150 lawsuits. Some of them were charging me $7 a document, and I was having to pay $1,000 every year just to file my leave of court. Most states do this built in your filing fee. In every other instance, the plaintiff pays the filing fee, and if they win their case, they recover their costs, those fees that they paid. This now compels a defendant to have to pay at least $30 per defendant to participate in a case, even if it's a frivolous lawsuit, or if they win the lawsuit. It is a change in our traditions in Georgia. I think it needs more time. I think we need to get it right. We have not been able to reach agreement through our conference. 2 of our 3 Senate conferees rejected this proposal, and I would request that you agree with me on Amendment 1A. Let's delete this civil justice package that the House was not able to get their way on last year, and let's deal with that separately in another bill, or let's deal with it next year. There are many counties that are already offering electronic filing. It is available. This is to lock in the monopolies that have already been contractually set. If a filing company has got a contract, it's a 2-year contract, this now, not only the people that have elected to use it, but everybody else in that court is forced to use them, that provider. That is not right. That's not what we're here to do. Let's have a civil justice system that's fair to all parties. It's well thought out, that we have enough time to develop and implement, rather than using a criminal justice bill as a vehicle for a civil justice matter. So I would strongly urge you to support Amendment 1A. That will delete those civil justice parts. Any of the lines that are before 145, if they're affected by this, I have no problem with that under number 1. If there are no questions, I'll yield the well.
No question, Senator. Oh, there is a question.
Okay.
Chair recognizes Senator from 17.
Does Senator yield?
I yield.
Senator, if your amendment does pass, does it potentially risk the governor's criminal justice reform bill getting final passage this session?
Not if the House recedes from their position and take it. And since you mentioned that, I spent about an hour today meeting with the governor's office and his executive council. In fact, they had asked me to bring in 2 amendments, one changing this date back to 2020 for implementation, and the other one was a technical provision about a council that they wanted to provide the rules and regulations that they had it wrong. Those aren't fixed in this amendment, so I had to try to give us time to work that out if that's important to them. But from the indications been given to me by the governor's office, they got problems with this bill as written and as amended. And we need to strike that, and let's start again on that. We might be able to get it done tonight through the agree process. I welcome any encouragement or suggestions from the governor's office to get this right. Thank you, Mr. Leader. I yield the well.
Thank you, Senator. Chair recognizes Senator from 23rd.
Thank you, Mr. President. Senators, mandatory e-filing in civil cases is something that the courts and the clerks have been working on for years. I've been part of that process, and I'm here to say that the time is now. Georgia is ready. The federal system has had it for almost 20 years. We're behind most of the other states. We need to do this. This is a much improved bill language over Senate Bill 15. It caps the fee at $30 for the first 10 filings. Filings can be hundreds of pages long. Our clerks are ready for this. It will help reduce redundancy and maintaining a dual paper filing standard with a computer standard. It will bring consistency throughout the state. The majority of our counties have e-filing. all of them have other mandatory e-filings for plats. The public, if you don't want to e-file, the public access terminals, which are already in place for plat filing, will help anyone who does not want to pay the fee. So I think the time is now. I don't think we need to put the governor's bill in jeopardy. It's clear the Judicial Council of Georgia will make and publish minimum standards and rules, and it'll be up to the clerks to carry it out. I urge your defeat of Amendment 2, approval of Amendment 1, and vote in favor of the bill as amended. Thank you.
Chair recognizes Senator from the third. 1A. He was referring to 1A, not 2, but 1A.
Thank you, Mr. President. I rise in support of Amendment 1A. The statement that all clerks are ready for this, that's not exactly correct. I know that I received an email today from one of my clerks in the circuit where I practice, just very concerned about the timeline of this, that she's telling me that they're not ready and that there are other clerks that may not be ready for this. Also, it will add more cost to have access to the courthouse. You already have to pay a $207 filing fee. This is another $30 for a plaintiff, another $30 for a defendant. And the defendant doesn't have any choice as to whether they're going to be sued or not. And for some, it may be a burden on them to have to come up with that $30. And I just think that we need to move slowly on this. We need more time. And as the senator from the 46th said, eventually we'll come to this. But just to push this and force this on this short timetable, it's not wise, and not all clerks are ready for it. Thank you, Mr. President. I yield the well.
Chair now recognizes Senator from the 17th speak to the bill.
Thank you, Mr. President. I realized when I was up here I didn't address these amendments. I just want to make it clear that as a full leader from the governor's office, Amendment 1 makes some changes to what the House added to the bill dealing with e-filing, and we believe Amendment 1 will address some of the concerns that some have with e-filing. I'm asking that you support Amendment 1 and oppose 1A. I want to make sure we get this criminal justice reform package passed in the governor's last term here, so I ask that you support Amendment 1 and oppose 1A. Thank you.
The question. Chair recognizes Senator from the 30th.
Mr. President, parliamentary inquiry.
State your inquiry.
I would like a ruling on 1A to see if it's done correctly, because what I see on that thing is we're amending the House substitute.
You are correct, Senator. However, the senator, I think, consulted with the Secretary of Senate, and the amendment has been corrected. It would be a Senate amendment to the House substitute would be the correct way of doing that. He can withdraw his amendment and redo it. He's already filed it, but I think just to be clear to everyone, it is a Senate amendment to the House substitute, which would make it germane.
Thank you, Mr. President. I was hoping that we could end this 2-year process instead of dragging it on another one. So,
right. And all those in favor of Amendment 1A will rise, stand, and be counted. If you're in favor of 1A, rise, stand, and be counted. Reverse. We got one back here. On Amendment 1A, the yeas are 14 and the nays are 26, and the amendment has lost. Question now is on Amendment 1. Is there objection? Without objection, Amendment 1 has been adopted. Question now is on the question before us. Agree to the House substitute as amended. All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. On the motion, the ayes are 49, the nays are 2, and the Senate has agreed to the House substitute as amended. Senator from the 36. Yeah. Senator from the 36, are you ready to move? Let's move yours off the table.
Mr. President, I'd like to be recognized to move House Bill 195 off the table.
Read the caption.
House Bill 195 by Representative Harold 106 and others. Bill will have enactment Part 1 of Article 2 of Chapter 5 of Title 40 of the OCGA, relating to property tax exemption so as to allow certain for-profit corporations to participate in the indirect ownership of a home for the mentally disabled for primarily financing purposes and for other purposes. Mr. President, Senate Committee on Finance offers the following substitute to HB 195. A bill be titled enactment Part 1 of Article 2 of Chapter 5 of Title 40 of the OCGA, relating to property tax exemption so as to allow certain nonprofit charitable institutions to exempt buildings used for the primary incidental purpose of securing income from property tax and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from 36. Is there objection from removing it from the table? Without objection, the bill will be removed from the table. Senator from the 36 recognized.
Thank you, Mr. President. Colleagues, House Bill 195 is a very simple bill that simply clarifies that a building can be exempt from ad valorem taxes when owned by a charitable institution used for charitable purposes and has the primary or incidental purpose of securing income for that 501c3. I would ask your favorable vote. This does require a 2/3 majority vote, and then will be a vote or referendum after that. So I yield for any questions. The Salvation Army, the Goodwill Industries, most of us have some similar building like that in our district, and this clarifies that they can use that building for events and to support their charitable purpose of their organization. If there are no questions, I'll yield the well.
There is a question. Chair recognizes Senator 28 for a question.
Yes.
Senator, do you yield?
I do.
Senator, are you attempting to reduce taxes?
There's with these buildings are not paying taxes now, but there's some overzealous tax assessors in Fulton County that are contemplating actually charging ad valorem property tax for these nonprofit institutions.
No way.
So,
thank you.
hard to
Senator.
believe, I know, but that Fulton crowd's kind of got a reputation for that. Appreciate your support. Thank you.
Where is the senator from the 36th, and who has she become? I love it. I tell you, taxpayer champion would be a great campaign ad. Senator from the 31st, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
Is it true that this bill requires a 2/3 vote?
It actually does.
Then when this bill was, according to the online version, on March the 27th, we voted,
or does
perhaps that was a motion in gross. I'm sorry.
All right. Questions on the adoption of the committee substitute is objection. Without objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is the objection agreed to report of committee which fail pass the bill? Chairs none. Report of committee is agreed to. All those in favor of the bill, the very conservative tax cutting bill, will vote aye. Those opposed, no. Secretary, unlock the machine. Yes. On the passage of the bill, the yeas are 49 and the nays are 0. This bill has passed overwhelmingly with the imposter that showed up to present it. Okay, let's. Chair recognizes Senator from the 56th.
Thank you, Mr. President. I move the Senate disagree to the House amendment to the Senate substitute for House Bill 93.
Read the caption. 93.
House Bill 93 by Resident Corbett of the 174th and others, a bill we titled an act to amend Code Section 48.2, 35.1 of the OCGA relating to refunds of sales and use taxes, so as to provide that no interest shall be paid on refunds of sales and use taxes to a purchaser that holds a certificate or exemption letter if such purchaser did not use such document and for other purposes. Mr. President, that concludes your.
The senator has moved to disagree to the House amendment to Senate substitute to HB 93. Is there objection? Without objection, the Senate has disagreed. Chair recognizes Senator from the 56th again.
Thank you, Mr. President. I move that the Senate disagree to the House amendment to the Senate substitute for House Bill 149.
Is there objection? Without objection, the Senate has disagreed again to the House amendment to the Senate substitute to HB 149. All right, we're going to stand at ease for our supper break. We'll be back at 7:30. 7:30. The governor will be arriving after our dinner break. If you would please make efforts to be back.